Thank you, Mr. Chairman. Thanks again for all of you being here. I don't know if y'all know there's a presidential debate tonight, so I'm kind of in a debate mood. And so, Mr. Mittal in particular, if you happen to want to take a counter view to any opinions expressed, if you'll just raise your pencil or piece of paper, we'll give you equal time. But I want to start with Mr. Kiani. The Prevail Act requires accused infringers to choose one forum to pursue their their challenges. Pete Tabor, District Court, can you explain why it's so difficult when you have to fight on both fronts?
Senator Tillis, yes. First of all, sorry, Senator Tillis.
Red means on.
Thank you. I apologize. Yeah, it's very challenging to be in both courts. However, I'm a big fan of the jury because it gets rid of bias. And the jury does a great job handling sophisticated patent cases with the judge overseeing through Markman hearing the claim construction parts. So, yeah, the problem we have, as I kind of alluded to it, Eastern District of Texas was a place that people that wanted to harass companies would go to file patents against them. And that, we have laws now against that. But unfortunately, PTAB, with an 80% kill rate, is kind of like the Eastern District of Texas for defenders. So they always choose that. And then they ask the court to stay the trial till they get what they expect, which is kill your patents. And if I may, since you're in debate mode, I take a different stand where Mr. Armand said, it's a good thing when we get one claim. No, it's not. It depends what claim you get. One claim is not good for inventors. In fact, it's most of the time the weakest stuff that, by the way, the defender is not worried about.
And Congressman, I hope I have an opportunity to ask you a question, but I love the fact that we have someone here so we can actually understand congressional intent. It's amazing how, even with bills that I passed in the last Congress, how people think I intended something different. I said, why don't you just call me up? So I'm glad we were able to call you up and get clear on what you had in mind when you were working with Senator Leahy. Ms. Armand and Mr. Mittal, I think this is probably one where you'd want to go in. We're talking about changing the standard from preponderance to clear and convincing. I think in your opening statement, you said you had a problem with it and you gave some history, so I'm going to give you a chance to repeat that. But let's start with you, Ms. Armand. Why is that a good or a bad idea?
I think the question is do we want consistency? So the administrative proceedings, the reason we had that originally is because it was an administrative proceeding, and that is the standard that the Patent Office applied. We have seen over time the Patent Office has harmonized more with district courts because these PTAB proceedings are like mini litigations. So if we want both trials to be similar, having the same standard of proof, I think would be helpful, but also at the same time, it's not going to matter necessarily in every case. A lot of the patents that go up, they're either clearly invalid or they're clearly not invalid. And so it's probably going to only make a difference at the margins, but that consistency, it exists, the Supreme Court has recognized, and the question for the committee is, do we want to be the same or do we want to treat the PTAB more like an administrative agency?
Mr. Mittal.
Now, the reason you apply a clear and convincing standard in district court...
Microphone.
The reason courts apply a clear and convincing standard in district court is out of deference to the agency's expertise, out of recognition that a generalist court just doesn't understand the technology well. If the Patent Office granted the patent, you should trust the Patent Office to an extent. Again, when you're back at the agency, it's the same expert agency, and in fact, they've had a lot more analysis of the same claims, and they're usually considering prior art that wasn't considered the first time. An additional thing I'd note is that when you're in the PTAB, you do get a measure of deference for the examiner's earlier findings for the prior art that was actually considered during prosecution. There's a policy under section called Section 325D, where if it's clear that a reference was considered and the applicant overcame it, the PTAB won't institute on that proceeding unless it's a very strong case, and I've frankly never seen that happen. This is a good thing. This policy encourages people to be more forthcoming during prosecution. Frankly, if we really want to fix the quality of issued patents, we need to return to a system where it's more routine for people to conduct a search and a patentability analysis as part of prosecution. The current 325D policies encourage you to do that. You can bring the prior art, get it considered, and then it would be very hard for someone to use it in a PTAP proceeding. If we give people clear and convincing deference automatically, even for prior art that was never considered, that whole incentive goes away. But again, most importantly, the clear and convincing standard is supposed to be about deferring to expertise, and the agency is frankly more expert when it's reviewing these claims for a second time.
Thank you.